And that's kind of unheard of for dissenting judges to really go after their colleagues for this.
Hey everybody, welcome back to the channel today. We got another big hit in this roller coaster that is the Duncan v. Bonta lawsuit. We've talked about it a couple times over the last couple of weeks, and we're going to hit it again today. So we have brought in volunteer president of CRPA, Chuck Michelle, to walk us through it. Chuck, how are you today?
Good. Thanks for having me, guys.
Absolutely, and we definitely are grateful that you come back, that you came back. We figured you would, so thanks for being with us here today. But before we get in that, I just wanted to remind everybody, please drop a like, share, and subscribe to these videos. You can also hit the little notification bell so that you get notifications when these videos drop. Let's remember, we're talking about these lawsuits. We're also talking with the attorneys that are actively working on them. The information doesn't get any better than this, and this is why we want to follow along. So let's dive back into this, Chuck. Duncan v. Bonta. It's our appeal on the ban on magazines that can hold more than 10 rounds. It's gone from federal district court all the way up to Supreme Court. Bruin hit, remanded all the way back down. Then we had that unprecedented move by the Ninth Circuit. Can you pick it up there for us and describe to us what happened?
Well, you kind of have to understand a little bit more about where we've been before you can understand really and appreciate where we are. Duncan started the Duncan case challenging ban on the possession of magazines that can hold over 10 rounds, started in Judge Benitez's court. I want to say like 2017. We won then, and that was before Bruin had come down. We won under the Heller test. Remember, a Heller decision is about a gun ban, handguns in the home in that case. Bruin is about a gun possession regulation, handguns in public. Didn't try and ban the guns, it tried to ban where you could have them. So the Duncan decision went from Judge Benitez to a 3-judge panel, which is the first step in an appeal in the Ninth Circuit. We won there, and then it went en banc, which is an 11-judge panel. In front of that 11-judge panel, and they're supposed to be chosen at random, the 11 judges from the larger 24 or 25 judge panel of the Ninth Circuit, of the entire Ninth Circuit. We lost 7-4. That went up to we asked the Supreme Court to review that case. The Supreme Court sat on it. When Bruin came down, the Supreme Court vacated, in other words, wiped out the en banc loss and remanded the case back down to the en banc panel. The en banc panel then remanded it back down to Judge Benitez again in the district court, the trial court, and he did a whole bunch of fact-finding and considered a whole bunch of legal briefs that now made the points that had been made by the Supreme Court in Bruin about why the ban on the possession of commonly owned magazines is, even to the extent it could be more unconstitutional. It's now unconstitutional under Bruin. So we won that. The state appealed, and this is where it gets wonky. Rather than go back up through a 3-judge panel, the en banc panel took it straight from the district court. Rather than going through the district court 3-judge en banc, they elected to take it directly en banc. Now, they can do that. There is a provision in the rules for them to do that. But they maintained the same 11 judges that they had the first time around. So hold that thought. Meanwhile, the Attorney General asked for the district court, Judge Benitez's injunction, to be stayed, to be blocked until the case was litigated all the way through the appellate levels. They first got an administrative stay for 10 days, and in the process, they got dissents from the 4 judges. Remember, I said we lost 7-4 the first time around in en banc. They got dissents from the 4 judges, and some of those dissents fairly scathing and critical of the way the en banc panel had been put together the first time around to begin with, and critical of the fact that they did not allow it to go through a 3-judge panel this time around, because implicit was they knew the 3-judge panel, which would have been the same as the first time, would have upheld Judge Benitez's ruling again anyway. So they bypassed the three-judge panel, and the dissenting judges were very critical of that move. And that's kind of unheard of for dissenting judges to really go after their colleagues for this. So the administrative stay was extended for 10 days, and while the court considered whether or not to grant a permanent stay while the case is litigated. We submitted an opposition to that, but yesterday the en banc panel, again, with 4 dissents, decided to extend the stay of the injunction so that the law doesn't change. You can still possess the magazines that you got before the Prop 63, and you can keep the ones that you got during Freedom Week, which was the gap between the first ruling from Judge Benitez and Duncan and the stay that the state got. They learned from their mistake the first time around and made sure to ask for Judge Benitez to give them 10 days to appeal before his injunction went into effect this time. So there was no Freedom Week. So now we're back before the en banc. The en banc panel has decided, yes, we're going to extend the stay again. And again, we got some just actually unprecedented dissents from the 4 judges who believe that enough is enough. And that's literally what one of the judges said. You're dragging these people through this route all over again. You're not changing the composition of the en banc panel, which you really ought to do considering all the changes on the personnel of the court, which is mostly Trump appointees. And so there's this very, very critical opinion that also lays out why we should win. It's the en banc panel, one of the tests in deciding whether to keep a stay in place is what your likelihood of success is. And 7 of the judges joined this stay that said, well, here's all these other cases in other courts, district courts, not the courts of appeal, that have upheld bans on magazine capacity. So based on all these other rulings, we are probably going to lose. CRPA is probably going to lose. Well, the dissent said, no, you didn't apply any of the methodology from Bruin. You just cited this long list of half a dozen cases from other districts. And that's not how you're supposed to do this. So then the dissent went through an analysis, just like Judge Benitez did. This is a 71-page opinion, which is chock full of footnotes documenting every single point that he made and every conclusion that he drew. And the dissents did a similar analysis and said, they're going to win. So why are you extending this stay of the injunction? Why aren't you letting the injunction go into place and let people get access to these magazines that they're constitutionally entitled to have?
Well, yeah, I was curious to get your thoughts on this because I did read the majority opinion and I did read the dissenting opinion. Got a real, what we know now as a Judge Benitez vibe out of Judge Bumate. He went off. He, if I can remember correctly, he basically said if the Second Amendment wasn't, such an important right for people to have, the treatment of this court on the California citizens would be laughable. And then he does go into that. I was expecting a little bit more analysis, through the lens of Bruin to be done, or at least attempted to be done through the majority opinion, but it didn't.
Yes, they dodged it. They dodged it. And he criticized them for that.
Yeah, it wasn't really there. They did list those cases, which Bumate pointed out, were from lower courts. But other than that, it was basically, we see the merits of the state as winning, and the interest balancing test, favors the government. They didn't really state much more than that. Is that what you were expecting? Is that usual, or were you expecting a little bit more of a thought out?
Well, not really on. I mean, a ruling on a motion to stay an injunction is typically not as thorough as the ultimate ruling on whether or not we're right and the magazine ban is unconstitutional. They're going to have merits briefs filed, and the en banc panel has already set up a schedule for this. It's coming up pretty quick. We're starting to work on those briefs already. But you wouldn't expect a ruling on a motion to stay to be anywhere near as detailed or thorough as a ruling on a case, the case itself, on whether or not to take it to judgment. So it's not completely surprising, but in this case, I would have expected more than a string cite, a cite to 6 cases in other districts that upheld the magazine ban, because every one of them applied Bruin wrong, and they're all on appeal. So the only place we're really going to get a thorough analysis is before the en banc panel. And remember, we lost 7-4. We only need to change 2 post-Bruin minds on that 7-judge panel. We've already got 4. They've made it clear in their dissents that we've got them. So if we can pick up 2 more based on what Bruin says, we could win in the en banc. But in the meantime, we're looking at the United States Supreme Court for some relief. There's a bunch of different things that you can ask the United States Supreme Court to do. Supreme Court basically has what's called a shadow docket, which is where you request emergency relief. So we could go in front of the Supreme Court and say, hey, they should not have stayed this injunction. They should let this injunction take effect. You should overrule their order staying the effective date of the injunction until after the litigation is over, and let the law take effect. Now, we've tried that, and other gun rights advocacy groups, gun owners' rights advocacy groups have tried that in a number of other cases across the country, and the Supreme Court has not granted that relief. But there's no other case like Duncan. Duncan has been up and down and now back up, again. And there's no other case like Duncan that has all these dissents that really kind of critique and criticize the way the case is being handled. But there's another thing that you can do in the Supreme Court. You can ask for the court. Remember, the Supreme Court does not have to take a case. In order for you to get the Supreme Court to take a case on the merits, I'm not talking about the shadow docket. I'm talking about the main docket of the court, where all the cases are briefed, orally argued, and then a decision comes down sometime later. You can, and typically, you don't go to the Supreme Court unless you've got a judgment, or at least a preliminary injunction or a permanent injunction. And so then, remember how the case goes. You file your complaint. They have to file a response of pleading, an answer, or a motion to dismiss, or whatever. You go through discovery, or you fact find and submit expert declarations and take witness testimony, or whatever it is. Then you have a period of more motion practice, and then you go to trial. And at some point when that process is concluded, you get a judgment. That's what closes down a case. Supreme Court typically likes to get cases that have been litigated to final judgment. They don't like to come in the middle. But that's not always true, because there is a mechanism for petitioning the United States Supreme Court for to take review of a case, a petition for a writ of certiorari to review a lower court decision before judgment. And so we are looking into that now. That may be a viable way to go about this. There's only been 14 of those granted since 2019. So it's rare. It's lightning in a bottle. Okay, it's not easy to get that kind of relief. But as we look at Duncan and the road it's been down and up and down and back up again, and the dissents, this might just be the case where they would consider granting review before judgment and would look at what kind of games the Ninth Circuit has been playing, and look at the argument that Benitez did, and look at the conclusions that the dissenting judge did in his analysis in the motion, in the granting of the motion to stay, from which he dissented. And so this might just be a case that they would take. So we're working on that right now, doing some research and making sure that it doesn't jeopardize anything. Because remember, the Supreme Court, even if it's a highly profile, hotly contested case, they don't take many cases. They don't grant cert, which is they don't grant that petition for a writ of certiorari in many cases. Like 1 out of 100 gets in front of the United States Supreme Court to be heard. So again, it's lightning in a bottle, but we're looking into that possibility and may do that instead. One way or the other, we're going to seek some kind of relief from the Supreme Court, as long as it doesn't jeopardize. If we don't get the relief from the Supreme Court, we're still back in front of the en banc. We litigate that, win or lose. If we lose, then we go to the Supreme Court after judgment.
So, and yeah, I mean, there is it. No, it does, and there is speculation throughout the community right now of people who are reading the dissenting opinion of Judge Bumate and sort of asking themselves, when he is, saying these things like we have, the dissenting judges have warned that these rules have been broken, and we've warned you that we are going against the constitutional right. They're analyzing and wondering if this is a cue that they're trying to send to us of, hey, maybe this emergency relief is what, the path that can be taken there. But that speculation, will either come to fruition or not. And I'm sure that you're hard at work trying
you need to separate out in your mind. The judges are criticizing the procedures that were used by the Ninth Circuit. First of all, the procedures that were used to appoint the initial en banc panel, because some of these dissents say the deadlines were blown and they shouldn't have even had an en banc. And then the procedure by which on the second time around, by which they skipped the 3-judge panel that second time around, went straight back to en banc. And then the way that now the en banc panel that we're dealing with now was not redrawn, they didn't do a second draw to get a new panel. They stayed with the first panel the second time around. Those are all procedural objections, which make a difference. And I think they're going to get the attention of the Supreme Court at whatever point it gets in front of the Supreme Court. And maybe that's now, because they were so critical of the way this was handled procedurally. It's implicit that they tried to rig the game to get it back in front of a panel that they thought we would lose in front. I don't know if that's true. I'm not inside the Ninth Circuit, but some of the judges that were very critical of the way things were done.
Well, let's talk about that for a second and try to get the best overall understanding that we can, because whether it's true or not, that perception is definitely a real thing. Watching all of these unprecedented things happen, that perception is out there, to say the least. I'm sort of curious as I'm watching this, so we had Bruin, and we had a lot of cases remanded because of Bruin. I can understand that. But even since Bruin, we've had a couple of cases. One of them was ours, which was Junior Sport Magazine v. Bonta, that was remanded from the Ninth Circuit back to the Federal District Court. You also had the open carry case, the Baird v. Bonta case, that was remanded. In both of these situations, it seemed like a message from the Ninth Circuit to the Federal District Court, hey, we want you to look at this because we're kind of assuming you didn't apply this correctly. Can that be said about this case as well? There's got to be a reason these cases are remanded in the first place. And this is now the third time that it's been in front of this Ninth Circuit en banc, right? The first time when Duncan was...
if you count the decision on the stay, yes.
So they've had this opportunity, and they seem to be the only panel that has decided this way after the Supreme Court has already sent it back. So is there that sentiment with this case as well? And I guess the real question is there any repercussions for judges who are acting in more of a political nature as opposed to a constitutional one? Are there any processes?
As a practical matter, probably not. Although the Judiciary Committee could look into judicial ethics, or the Supreme Court could look at judicial ethics. I mean, this court system is essentially self-policing with a legislative oversight committee. But keep in mind, Duncan is the only case that's en banc right now. The Tedder case, which is the Hawaii butterfly knife case, the state of Hawaii has asked for en banc review, and they're probably going to get it, because there is a component of judges on the Ninth Circuit that doesn't want to accept the reality of the Bruin methodology. And that is what we are fighting about right now, not just in California, not just in the Ninth Circuit, but all across the country. After Heller, the courts distorted the Heller test, turned it into something that it was never designed to be, and used that distortion, used that inappropriate interest balancing test to uphold a lot of not a lot, but most unconstitutional gun control laws. They said they were constitutional because they passed Heller, but they weren't applying Heller right. And Bruin called them out on that, said, you haven't been applying our Heller decision correctly. Here's how you're supposed to do it. Look at the text of the Second Amendment. Is the conduct that's being regulated something that involves the right to keep or bear arms? It's just about all conduct. And in Heller it said, possessing a firearm in your home is definitely, for self-defense, is definitely conduct that's covered by the text of the Second Amendment. In Bruin it said, possessing a firearm outside your home for self-defense is something that's covered by the Second Amendment. So in Bruin they said, you can't not allow people to have the permit. You can't ban people from having a firearm for self-defense outside their home. But the way the methodology that applied was, yeah, carrying a firearm outside your home for self-defense, that's covered by the text. Keep or bear arms. Bear means carry. Keep means possess. And then it goes to the historical analogs and says, is there some law from back around 1791 that would indicate that the founding fathers, when they wrote the Bill of Rights and the Second Amendment, would have tolerated something along the lines of the modern day law? And in Heller, they said, and people get this confused because there isn't really a common use test. What there is a historical analog test. And what the Supreme Court found in Heller was that the only historical analog rules regarding firearm or arms bans were for dangerous and unusual types of arms. Handguns are not dangerous and unusual because they're in common use. So that's where the common use derived from. Common use defeats dangerous and unusual. Dangerous and unusual is a potential historical analog that to a modern day law. So if you ban some, I don't even know what kind of a weird, and it has to be exceptionally dangerous, obviously. Every firearm is potentially dangerous. An unusual firearm, perhaps that passes constitutional muster because there is a historical law that was kind of along the same lines. But when you're talking about handguns or magazines or semi-auto rifles or any other type of arm that is commonly possessed, you can't ban. The Bruin prohibits you from banning them. And so in all these cases that you cited, the Ninth Circuit is fighting about that methodology. They don't want to apply it that way. And states spoon-fed arguments from the Bloomberg Everytown Law Group. Folks might want to check a look at that Everytown Law website. You can see all the stuff they're doing and how much money they're spending doing it, fighting us. But they are trying to confuse the courts again, just like they did after Heller, and make them think that the Bruin test is something that it isn't. And that's another reason why the Supreme Court might want to get involved sooner rather than later, because that test is being so twisted and distorted by the lower courts.
Well, that's what I was sort of thinking. I mean, we're kind of talking about how the Ninth Circuit has sidestepped Bruin altogether in this particular granting of that stay. Is there some silver lining in that? I mean, whereas they were able to effectively misuse the Heller decision for a decade and a half, they have to completely just leave it out in order to rule the way that they want to rule right now. Does that really mean that if they try to use the Bruin methodology, that they just won't be able to do it, so they have to sidestep it completely?
Well, no, they won't sidestep it. They'll just twist it. I mean, these are smart judges. If they want to concoct some means to achieve some end, their predetermined end, they can do it. I mean, that's true in every appellate court. All you got to do is twist the facts a little, twist the law a little, and you come up with a recipe for whatever result you want. But it's not supposed to be that way, but that's the reality. The judges know how to play that game. It doesn't happen very often, but in high-profile cases, particularly where people's feelings are very, very strong, something they really, really care about, as Judge Van Dyke said, they're more inclined to maybe push things to achieve what they want to achieve.
Well, As always, I would feel ashamed if I didn't ask, what is the outlook that you have for this case from now going forward? And if you have any final thoughts, what are those?
Well, right now we have a briefing schedule in Duncan. And don't forget, we've got Rhodey, the ammunition background check law challenge coming out of Judge Benitez soon, maybe even tomorrow. And we've got Miller and CRPA's RUP case challenging semi-auto bans. Those will be coming out soon. And we've got, I believe it's Fouts, which is a billy club ban. Remember, it's not just firearms, it's other kinds of arms as well, just as the Hawaii butterfly knife case demonstrated. So there's a lot happening in the Ninth Circuit. Plus, you've got Baird v. Bonta. Plus, you've got our Bolin v. Bonta, the magazine ban case on appeal. Then you've got our challenge to SB2, the sensitive places cases going on down in the district court in Orange County now. Soon we're going to be filing the challenge to the sheriff, LA County Sheriff, for taking so long. It's taking over a year to issue CCWs, and also suing some of these cities that are charging $1,000 just to go through the application process for a CCW. So all of this stuff, and that's not even covering the other circuits. You know, there are all these tests coming up through the ranks, through the courts, that depend on how Bruin is applied and how the methodology of Bruin is applied. Rahimi in the United States Supreme Court may straighten some of that out, but that's not the greatest case for that, because that guy is not sympathetic. Rahimi is not a good guy in the eyes of the court. And so they may want to find a way to keep that class of people who are subject to restraining orders from being able to possess firearms. And so I think that's what the government is hoping, that they will water down Bruin, pull some of the teeth. Remember, the Second Amendment's been called liberty's teeth, and they do not want the Second Amendment to have any teeth. They want the Second Amendment to be impotent and essentially useless. It doesn't strike down anything. And so they chose that case because they knew it had unsympathetic cases, the plaintiff that was going to put some of those justices in a more difficult position. But that's another reason that they might want to take Duncan, because they can solidify the Second Amendment ruling now and then deal with Rahimi separately. There's a lot of moving parts, but it comes down to the Supreme Court's got to settle this issue, this dispute about the right way to apply the Bruin methodology, and we're looking forward to making sure that happens. And once it does, then everything's going to speed up.
Absolutely. Well, I mean, just a quick clarification, because I know that you got so much you want to express before the comment section blows up too much. The Duncan case is the case on banned magazines. The Bolin case is our challenge to the handgun roster.
Did I switch those?
I didn't want to interrupt you, but yeah. So before I just wanted to clarify that really quick. Well, Chuck, we're definitely going to be following along with this, and I'm sure we'll have you back in quick order. Thank you so much for sharing that with us today and taking the time.
Always a pleasure, guys. Thanks for getting the word out, and thanks everybody who's watching for your support. We give great rates to the CRPA and all nonprofits, but it still takes time and money to litigate these cases. And my lawyers are all working, overtime to try and keep these cases moving along, do the amicus briefs in cases across the country that need to be done to help the parties make all the points that they want to make. I mean, it's a national battle right now. I do think Ninth Circuit's kind of the tip of the spear right now, because Duncan, there's maybe one other case that is as far along on en banc review as Duncan is. So once again, the Ninth Circuit is kind of setting the pace and setting the tone for Second Amendment cases, but they are also the most overruled circuit in the nation by the Supreme Court. So we'll just keep fighting. You keep helping us out, everybody who's watching, and stay informed, stay involved, and we're doing. This is part of history. You're a part of history for being involved in this. This is a historical time for Second Amendment jurisprudence, and it's going to leave a lasting legacy, one way or another, hopefully in our favor, and I think it will. for generations. So thank you for your involvement.
Yeah, thanks again, Chuck. I appreciate it. And if you like these videos and want to continue receiving these updates, please like, share, and subscribe to these videos. Hit that little notification bell. It helps us out a lot with the algorithms, and it helps you actually get the notifications when we drop a video. Like I said earlier, you're hearing this information from the attorneys that are working on these cases. So if you like that, please come along for the ride with us. We have also started dropping the CRPA link in the comment section. If you do want to be a part of these cases, whether you're California or not, you can go ahead and join there. That goes towards these lawsuits. So if you want to stop the Ninth Circuit from exporting bad laws to the rest of the country, or bad decisions to the rest of the country, or you're in California and you want to help contribute toward that fight, please feel free and click that link and join CRPA. I appreciate it. Thanks, guys. We'll see you on the next one.